మీకోసం మరింత రంజుగా
अब तू देख लेगा बच्चन साहब का खेल।
డౌన్లోడ్ ఆహా నౌ.
ఆకర్షణీయమైన చీరలు, అప్పురపరిచే ధరలు, అందరికీ నచ్చిన అందరూ మెచ్చిన షో మన లక్కీ మహిళ. బోలెడంత ఎక్సైట్మెంట్, వండర్ఫుల్ విన్నింగ్ మూమెంట్స్.
ఎగ్జాక్ట్ చెప్పారు, మీరే గెలుచుకున్నారండి. కంగ్రాచులేషన్స్, $220.
సెలబ్రిటీ హోస్టులు, అదిరిపోయే పంచులు, సరదా సరదా కబుర్లు.
ఆశ దోశ అప్పడం బడ హెల్ప్ మీరు ఆడుతున్నారు.
ఇలా మరెన్నో మెమరబుల్ మూమెంట్స్ తోటి 3rd యానివర్సరీ జరుపుకుంటోంది మన లక్కీ మహిళ. Watch it live only on TV Asia Telugu. మీ అందరికీ 3rd యానివర్సరీ శుభాకాంక్షలు.
మలబార్ గోల్డ్ అండ్ డైమండ్స్ ప్రపంచంలో పెద్ద జ్యువెలర్స్ లో ఒకటి ఇప్పుడు డాలస్ కి వచ్చారు. అందమైన తేలికైన జ్యువెలరీ డిజైన్ల నుంచి చేతో తయారు చేసిన అతి క్లిష్టమైన కలెక్షన్ల వరకు 20 దేశాల నుంచి 30,000 విధాల ప్రపంచంలోకెల్లా ఉత్తమమైన జ్యువెలరీ డిజైన్ల అనుభవాన్ని పొందండి. 5,000 చదరపుటడుగల విలాసవంతమైన షాపింగ్ ఏరియా మలబార్ గోల్డ్ అండ్ డైమండ్స్ షోరూమ్ ని డాలస్ లో విజిట్ చేయండి. ప్రపంచ స్థాయి జ్యువెలరీని కొనుగోలు చేసే అనుభవాన్ని పొందండి. Malabar Gold and Diamonds now open in Dallas.
గెలుపే ఊపిరిగా, పట్టుదలే ప్రాణంగా, ఆశయమే గమ్యంగా పోరాడే యోధుడికి విజయం
Yet another fabulous show of our talk show with experts. మనతో ఉన్నారు మన ఎక్స్పర్ట్ రాహుల్ రెడ్డి గారు. రాహుల్ గారు, thank you so much for being on the show today, Andy.
Thanks for inviting me, Garu.
Awesome. So this show has been brought to you by Malabar Jewelers. By the way, guys, they've opened a brand new store in Dallas. So don't waste any time and go with the gold rush and buy yourself the best. Supported by movers.com and AHA OTT platform. Watch us on Yup TV, Facebook, YouTube, Sling TV, World BBTV and Dish Network. All right, folks, without any delay, let's come to the topic for today. This is a very interesting topic, Andy. The immigration implications of Indian students surpassing the Chinese students in the US. So, Rahul Garu, can you give us a little brief about how do Indians and Chinese students differ in terms of their academic and career interests, and what is there any implication in the first place?
Yeah, there will be a lot of long-term implications, Nitya Garu. Because the Chinese students, they typically come for bachelor's and master's though. But when it comes to the Indian students in USA, they do come for the master's degree only. Most of them. I mean, the amount of people who are coming for bachelor's degree is increasing year by year from India because of the, people affordability in India has been very high there. I mean, they're able to afford colleges here. But there is another stats though, what what is going to be bothersome for us is that the amount of people after they complete their education and after they complete their OPT or STEM extension, how much of the amount of the Indians will stick around in USA as compared to the Chinese nationals. If you look into the stats though, it's always been historically Chinese were dominantly getting the F1 visas. They were dominating for the last 15, 20 years though. And the amount of visas that were being issued for them is almost double than that of Indians. Yet when it comes to the H1B, we don't see the same rush of the Chinese people on the H1B. We don't see the same rush of the green card for these people. So what's happening is that after they complete their bachelor's degree or master's degree, they go back to their home country, but Indians tend to keep around in this country. So we already know that the H1B numbers, is always like there are like 1 to 5, 1 to 4 is the application numbers that are going on. Going forward, what will happen to the students who wants to stay in this country after they complete their education though? They may be forced to get out of the country because they won't be getting the H-1B visas because the lottery will not be available. And the amount of people who are waiting for the green card for India is already 100, depends on whom you ask, but even if you file a green card, it may be anywhere between 80 years to 140 years for you to get the green card. Now, with addition of these people coming in, if there are no changes in the H-1B or green card, we will have a major problem there. That's as far as the US is concerned. As for the students who are coming into the country, their expectation is, okay, I complete my master's degree, I'm going to get a H-1B, eventually I'm in the path of the green card. Of course, most of the people now know they're not going to get the green card soon, but at least they know that their H-1B, they are going to get it. Now, if the H-1B is going to be the same way what happened with the green card, then there will be a lot of backlog for H-1Bs. So that may, the mentality of Indian students when they're coming, please be prepared that if you don't get the H-1B, what are your plans?
What are your plans? Got it. So Rahul garu, also what are the latest statistics and your Indian and Chinese students who are studying here? Like
it looks that the statistics which have been provided at this point of time are not up to date because they didn't take into account. In 2022 though, approximately 100,000 Indian students got their F1 visas though. 100,000, that's 1 lakh people got it. Now, when it comes to the Chinese nationals, approximately around 65,000 people got the student visa in 2022. Okay. Now, here is a stats where they're showing is, right now there are 300,000 students in USA that belong to Chinese, but only 200,000 students that are of India. But I think so that statistics is at the end of 2021. Now that may reverse up right now where Indians may be almost to 300,000 and Chinese may be 250,000 though.
Okay.
So this is a first time. If I have to tell you, 100,000 students got the visa this year. If you recall that in 1993, about 30 years ago, the amount of people that got the visas at that point of time is about 10,000. So in the past 30 years, 1993, in the past 30 years, so it went up by 10 times. So if this trend continues and the H-1B and the green card remains the same, it's going to be a disaster because people's expectations and the H-1Bs is going to be a disaster in the long term.
Yeah, because we do generally discuss about like H-1Bs and green cards, but on behind the scenes kind of a thing, this is like changing the inherent fabric of immigration itself.
Right, that is right. It's going to change the fabric. That's a perfect word that you indicated. It's going to change the fabric of the Indian immigration. What is the path for them to get a H-1B? What is the path for them to get a green card? So right now, getting a green card in EB2 and EB3 is completely, you're not going to get it if you file right now. So could it be the same thing for H-1B? Luckily in H-1B, there is no lottery system, especially for Indian nationals though. But still, the amount of Indians that we occupy almost 60% of it. Could we occupy 70%? Could we occupy 80%? Is that good enough for us? If 100,000 people are coming in, remember that these are not the only people who are competing for the H-1 visas. It's also the people who are working for Google, Microsoft, Wipro, Tata Infosys that are working in India that are also trying to get into the country in H1 visa.
Wow.
So it's going to, it may become a lot more bigger lottery pool for the H1B, and lot less people of Indian nationals can get into the lottery pool. So we'll have to see. The politicians need to also understand this. Students need to understand it when they're coming. What is their expectation?
Rahul, just one quick question before we start taking our callers. Is there, are there some courses or, some branches of education that are preferred in terms of being able to get a quicker H1 or a visa, or versus some of the others, or,
No.
Everybody's into STEM these days, but are there other opportunities that they should look at,
In the H1B, there is no difference between whether you are whether you're a doctorate, whether you are an IT professional, whether you're an accountant, whether you're a lawyer, whether you're a doctor. Well, I have to give one exemption to doctors. I'll explain that later on, though. But other than doctors, though, practically everybody has to go in the same line. The only people that are exempt is the people who go and work for higher education nonprofit institutions. They're exempt from the H1Bs. So especially if people are not getting in the lottery, you may want to consider working for these educational institutes, higher education institutes, get exemption from H1B and then work on a non-exempt H1B. That's one thing. There is a slight exemption for doctors who work in a rural areas for the H1B. They move on from J1 to H1B. There is an exemption for them. They don't have to go through the lottery system like the rest of the people. So that's the only thing. So whether you're a scientist or whether you're an IT professional or accountant or lawyer, you fall into the same category. Nothing different for you.
Okay. All right. Thank you, sir. And on that note, let's take our first caller for the day. All right. Caller with number ending in 0683. 0683. We're ready for you now. Hello?
Yeah. Hi, Rahul Garu. Good evening, Andy. So I have one question. My EB2 priority date is 2020. So this month I have applied EB1 as a porting because I'm eligible in EB1C now. So my question is, my attorney suggested don't go for premium, instead of that apply for 485 on medical. So I'm in confusion whether should I go on premium or
go for the premium. Go for the premium. The stats does not say that if you are going for premium, you are getting a more RFEs or more denials. What does the stats tell you is one thing, is that if you file for the premium, you're going to get the result faster. Okay, that's for sure. No lawyer can deny that, is right? I mean, you're going to get the result. I would rather get the result faster rather than later, though. Okay?
Okay. Thanks. Thank you.
Thank you, sir. Thank you so much for calling, Andy. Let's take our next
Nitya,
caller.
that also applies for H1B, L1s, all the visas, guys, that the premium processing is. People are under the assumption if you do the premium, RFE will come either way if it has to come. Denial will come. The only thing is it comes faster.
Okay, got it. Yeah, might as well, right?
Yeah.
Okay, thank you, sir. Let's take our next caller. Caller with number ending in 2776. 2776. We ready for you now? Hello?
Hi, Nitya. Hi, Nitya. Hi, Rahul. Can you hear me?
Yes, sir, we can hear you. Please go ahead.
Yes. Actually, hi. Thank you for taking my call. I had a question regarding travel on advanced parole. And the question was, so my wife is on H4 EAD. She's working on H4 EAD, and both of us are traveling to India. And we were just wondering, when we come back, does my wife need to switch to GC EAD in order for her to continue to work, or can she continue working on H4 EAD?
So you both will be coming back on advanced parole into USA, is that right?
That's correct. Yes, that's correct.
No, sir. She can continue working on H4 EAD.
Okay, she can continue working, because there is conflicting information online in terms of what
Yes. I know what you're speaking. There is a lot of difference of opinion on it. She can extend the H4. She can extend the H4 EAD when she comes into the country.
Okay.
Okay.
And one other follow-up question was, sir, in terms of what kind of documentation do I need to carry, on our way back in order, at the port of entry?
485, only 485 receipt notice and advance parole. Of course, passport. I don't have to explain you about it. That's it. Rest,
Okay.
anything you want to carry,
Okay.
carry it. You don't have to tell me. Okay. But when you
Okay.
come to the
Okay.
port of entry, though, there is a chance they will take you to most of the post of entries. They will take you to a small room. Don't be bothered
Okay.
about it. That's a normal process for advance parole.
Okay. Okay. Great. Thank you so much, sir. Thank you. Thank you.
Thank you.
Okay. Bye-bye.
Rahul Garu, that's the secondary immigration check room, right?
Right.
Sorry.
It's called soft secondary. Yeah. Soft
Soft
secondary.
secondary.
There's two
Yeah.
secondary. There is a hard secondary. They'll put you in a room that will have a toilet but not flush. That means that if you're bringing some drugs or something, you can't put it in there. So those kind of things are also called a secondary thing. Okay. It's called soft secondary.
So I've been to the soft secondary a few times. So
Yeah.
thankfully never have had to go to the hard secondary. All right, Rahul Garu, before we go on to our next caller, I have a question for you. This is from Zoravar S. Says, if I go for H4 I-94 extension to Cancun or Laredo, Texas border, is this the person who called? Based on my wife's H1B 797 approval, will my H4 or H4D EAD extension be voided as I'm going outside the country? No, yeah, this is the other one.
First one is that there is a chance that the H4 will be voided. But my question to you is that why do you need H4? You already got the extension. If you get the extension, you don't need an H4. The EAD will not be voided, will be approved.
Oh, okay. Simple as that. All right, thank you, Rahul Garu. Let's take our next caller, Andy. Okay. Caller with number ending in 6633. 6633, we're ready for you now. Hello?
Hello.
Hello, sir.
Yeah, Rajkumar here.
Hi, sir.
Hello.
We
Yeah, I
hear
can hear
Please
you.
go ahead. Yeah.
Okay. My question to Rahul Garu is, my son is on H4 and he is going to college, and I want to convert him to F1. But my question is, because there may be a waiting time for, let's say, 11 months or 10 months. So
You're right.
his H4 is expiring in August 2023. So should I apply now for H4 to F1? And while we are
Absolutely
waiting for F1, if it's no, okay.
No, I said apply right now. Go ahead. You keep going.
Oh, apply right now. Okay. Apply right now. But if his H4 expired and we are waiting for F1, then what we need to do?
Nothing. In May of 2022, USCIS has issued a website update in which they said that if the child is turning 21, they don't have to do a bridge B2 application, which we used to do before. So what we used to, let's say, for example, your son is becoming 21 in, let's say, January of 2024. If by January of 2024, you didn't get the F1, we used to apply for the B2 visa until he gets the F1 approved. But they said we don't have to. So even if your son turns 21 and he gets kicked out of the H4, and while F1 is pending, he is in good shape to stay in the United States, good shape to go to school too.
Okay, so we don't have to worry about his H4, even the H4 is expiring next 4 months, but as long as we applied for F1, we are good.
That's right. You're absolutely right.
Okay. Thank you very much.
All right. Thank you, sir. Thank you so much for calling in.
Nitya Garu, I just
Go ahead.
want to caution people who are becoming 21. I want them to apply when they are in like 19 years and about 8 months. There is another reason is that some of the time what happened is that by the time F1 is approved, they are already graduating from this college.
Okay.
Then what happens is that we don't get the OPT and STEM extension.
Correct.
Okay. So that's the reason why applying. But this 21 years is not a problem, but they coming near to graduation is a problem. Actually, if they graduate, they won't even get an F1 visa. So.
Oh, that's interesting. All right. Thank you for
And
that.
Rahul Garu, what is the waiting time?
11 months to about 17 months.
Okay, thank you.
All right. Thank you, sir. Thank you so much for calling, Andy. All right, Rahul Garu, question for you, sir. Give me 1 second. This is from Shaili Honrao. Says EB1A 485 filed more than 6.5 months ago. Priority date is Jan 15th of 22. I fear further retrogression. Should I contact the local congressman to inquire or push the USCIS regarding my case? And does this approach help us, or should I just be waiting?
So if you typically contact the local congressman, though, the problem is that when you contact the congressman, this is not like India, where the Lok Sabha MPs have a lot of power. You know what their power is, right? Here, when you say contact the congressman, what exactly do you do? There is an immigration assistant web link for each congressman, which are about 500 plus, okay? Now you go there, you fill the information. From there, nobody even looks into it. It automatically goes to the USCIS, or maybe one of the 30 clerks looks at it for a minute and passes it to USCIS. The USCIS, on the other hand, they have a liaison officers. What do you mean liaison officers? Means they are going to respond to the congressman. There are a couple of people that they employ. And they responded automatically saying, yours is in the line, the processing time is 27 months. You are been only pending there for 11 months, so you are not going to get it. The automatic response goes in. Okay. So it may, if it is completely out of whack, where it's 27 months and you are 36 months, or if it's something completely bad though, it may get the attention of them. But if it's a normal, but people ask, oh, out of tens of thousands, one gets adjudication done and they praise the congressman, okay, that's fine. You can do it, it won't harm you. But my suggestion to people is that we need to sue the USCIS. We have seen how suing the USCIS worked in the IT serve litigation, where when the IT serve sued the USCIS, they done away with the end client letter, completely done away with the end client letter. Remember, we used to get 6 months and 1 year extensions in the Trump era. It was not within the Trump era itself. We went to the court and we got rid of those things too. And we had this H4 EAD litigation too, which we got benefited to that too. So all these things where H1 and H4 and EAD are going to be approved at the same time when we went to the court. Yes, the court responds if you have a thing, especially for EB1s, if it's been pending for more than 6 months, you should contact a lawyer to sue the USCIS.
Okay.
Only if the I-140 is approved.
Okay, yeah, she doesn't mention that. So if you're watching, then please know this. All right, thank you, Rahul Garu. Let's take our next caller, Andy. Okay, caller with number ending in 2415. 2415, we're ready for you now. Hello?
Hello, hi. Can you hear me?
Hi, sir. We can hear you. Please go ahead.
Hello, Rahul Garu. My name is Nikhil. I have my H4 and H4 EAD approved for a future date starting in May 2023 based on my wife's I-140 approval. But it is only valid for like 3 months till October of this year. So my wife is planning to apply for her H1 extension along with that my H4 and H4 EAD too. Is it H4 and H4 EAD as well? Is it recommended that I wait till my H4 kicks in, which is in May, or because I'm currently on my H1, can I still go ahead and apply for my H4 and H4 EAD renewal?
No. You can apply for it right now. You don't have to wait. So if her H1B is expiring in October, she will be eligible to file for the H1B extension in April, is that right?
Yes.
Yeah, you can apply in April. You don't have to wait until May, sir.
Like my wife's attorneys are suggesting that I wait till May before I apply for my H4 before I apply for my H4 because technically I'm applying for H4 extension, but I'm not on H4. Is that going to be a problem?
Either way, it's not going to be a problem for you. To wait one more month, that's up to you if you want to wait. Okay?
And based on the litigation
I don't understand why you applied with the future date H4 plus EAD though. We advise people never, ever, ever do that.
Okay, yeah. At that point of time, it seemed like a appropriate idea. I have one follow-up question. Based on H4 EAD litigation, are the H4 and H4 EADs getting, or H1 and H4 and H4 EADs getting approved together now?
Yes, absolutely they are. You can thank us for it.
Okay,
we are part of the, we are the persons who sued the USCIS, and we're getting paid $20,000 for it from USCIS.
All right, thank you so much for that. Thank you, Rahul Garu.
Yeah.
Thank you, sir. Thank you so much for calling, Andy. All right,
Thanks.
let's take one quick question before we go to our next caller. Question from Surbhi Verma says, Dad visiting US with a B2 visa plus Canadian visitor visa. Plan to take him to Canada by driving. Will it cause any problem for US re-entry from Canada or any special documents to be taken?
First of all, we don't know if he has a visa to go to Canada though. He needs to have a visa to go to Canada.
He says
Second
Dad
thing,
has a Canadian visitor visa. So,
okay, got it. That's good. What's the purpose for the dad to go to Canada? Is it to extend the stay in United States? Don't take him because of that reason. But let's say, for example, your dad has been visiting and you just want to take him to Canada and he's going to leave within 6 months after he came into United States. We don't see any problem whatsoever at all for him to go to Canada and come back.
okay. Got it.
Visiting visa doesn't mean that your dad has to visit from India to here. He can still come from Canada to here too. That's perfectly okay.
So technically, Rahul Garu, then can we extend a person's visitor's visa if we do a Canada and trip and re-entry? So
Not a good idea.
Yeah,
Not a good idea. One thing is that they will normally allow you to just come in the same I-94 though. They won't give a new I-94 when they come into this country because you're there only less than 30 days and coming into this country. The second is if by any chance, let's say the I-94 is expiring in February, let's say February 28, okay? And you left to Canada and you want to bring in March 2nd though. Okay, that means he already stayed 6 months. If you are going to expect him that he's going to come back and they're going to give 6 months again, they may actually put him in deportation proceedings too.
Oh.
The reason is that, Nitya Garu, the visiting visa is given not to visit Canada, but to visit USA. What do I mean to say is that the dad already stayed 6 months in USA. He can visit Canada. But remember, 6 months here, he's visiting Canada, but remember, he used to visit USA. For 6 months he stayed and he's coming back and he's intending to stay for 6 months. Looks like he's staying in USA.
Makes sense.
Which he should not be. Yeah.
Right. Okay. It's good to know that because I'm sure people would be thinking about trying out this option, but it's good to know what are the
That's only for H4 we recommend people going to Canada or Mexico. The reason is that there you are telling that my husband is working for Pepsi and I am the lovely wife of my husband. Nothing wrong with it. I know you fight sometimes, but it's nothing wrong with it. You're okay with it. And your intention, when you're coming back is that I'm going to stay with my husband. I'm going to love him. Fine. You're good. Come on. You're okay. We'll extend you.
Okay. All right. Thank you, sir. Let's take our next caller. Caller number ending in 0875. 0875. We're ready for you now. Hello.
Hi, Nitya and Rahul.
Hi, sir. Please go ahead. We can hear you.
Yeah. Thanks for taking my call.
Sure.
I have a question. Yeah. So I got laid off at the end of December, and I'm in my 60-day grace period. But yeah, so my same employer who laid me off, they are trying to hire me back. So they filed
Another
they
H1B.
filed another H1B.
Keep going.
Because I got a new client.
Keep going.
So they filed an H1B. So they filed it. So the thing is that the grace period is going to end soon. And I don't know how long it will take for the H1B transfer decision.
The H1B doesn't have to be approved within the grace period. It has to be filed. So they already filed.
Correct. Yeah, but thinking about the worst case, what if my H1 gets denied?
There is a possibility because right. There is a possibility they may allege that this company is avoiding the paycheck. That's the reason they have let him go and hiring him back. Though, do the premium processing. That will solve the problem.
Yeah. I mean, I have done premium processing. It's been done through premium processing.
If it gets denied at the most, though, you will still get a H1B approval without the I-94. You just have to go outside the country to validate your H1B. Are you following?
But if it gets denied, that is denied, right?
If it's denied completely, yeah. If it's denied completely, then you will have no option but to leave the country.
Yeah. So I'm just thinking about my other options because I have my I-140 approved. So even before my 60-day grace period is done, will I be able to apply for the compelling circumstances EAD? Like while the H1 transfer
you mean to say while the H1B transfer is pending, can you? Yes, absolutely you can.
Correct. Okay.
Absolutely you can.
But what if I file it within the 60-day grace period, what if later both are approved? The H1B is approved and then my
once the H1B is approved, you can withdraw the compelling circumstances EAD. You don't need it.
Oh, okay. So I can proactively withdraw it, like send a letter to USCIS saying that I already got my H1 approved, so I don't need the
You're
compelling.
absolutely right. Yeah. Next person, please.
Okay. Thank you very much.
Thank you, sir. Thank you so much for calling, Andy. Let's take our next caller. Okay. Caller with number ending in 5086. 5086. We're ready for you now. Hello? Hello?
Okay, so I can...
Caller with number ending in 5086. Hello, sir?
Hi. Hi, this is Sunita. Thank you for taking my call, sir.
Sure, ma'am.
Hi. Can you hear me, sir?
Yeah, we can hear you. Please go ahead, ma'am.
Okay, thank you. So I have a question for my son. Currently, he is working with a company on CPT, and he already applied for OPT from June 1st date. But the thing is, he got selected for a company, and he'll be starting his work with employer B from July 1st. But the thing is, employer A, where he is working for CPT, they are ready to file H1 as a future employer because from he can start a H1 also right now, right? So here is our question, but he is more interested in the second company, which he'll start working from July 1st, but he don't know whether they will apply for H1 or he doesn't know anything. So our question is, if his H1 gets approved with employer A, can he transfer to the employer B in the month of July or in the month of October?
Definitely not in the month of July, but in the month of October he can.
Oh, okay.
But there is another issue that you need to be very careful about, is that if he is going to move to in July though, what if the company A withdraws the H1B before October though? Then that H1B will not be counted toward the H1B lottery. Are you there, ma'am?
Oh, okay.
So, especially since he's... Go ahead, sir.
Sorry. If his H1 is approved, until then he is with the company A, or he is not on H1, but he is working on
even
OPT.
Right. I got the point. So between July 1st and October 1st, though, he will be an OPT. Here is the problem, though. The company can withdraw the H-1B before October 1st. If they do it, then that H-1B is not counted towards the lottery. Okay? And here is another problem.
Okay.
The CIVIS system kicks him out saying that, oh, he has a H-1B. I don't know who built the CIVIS system. Definitely not our H-1B people, okay? What happens is that the CIVIS system says that, oh, this kid got a H-1B. You guys know what a CIVIS system is, right? The online system for the F-1 visa students.
Yeah.
So that will kick him out saying, that, oh, you got the H-1B, he kicks out. And since the company withdraws the H-1B, he is not an H-1B, then in Telangana Hyderabad language, we call it as he will be na garka na gatka.
Okay. So my question is in other ways, suppose nothing happens like withdrawal. So we have good terms with the company A.
Yeah, if
company
nothing happens in the
filed
withdrawal, company A files gets H-1B, works from July to October to company B. Company B can file H-1B transfer starting on July 1st. I'm sorry, October 1st.
October 1st. So he no need to work with the company A on H-1B, right?
No, he doesn't need to work with company A.
Okay.
Yeah.
Okay.
Next person,
Thank
please.
you. Thank you very much.
All right. Thank you, sir. Thank you so much for calling, Andy. All right. Before we take our next
Nitya,
call,
I didn't want to argue with him. I didn't want to argue with him, but I just want people to plan carefully in these things. The reason is that he already left the company A to company B in July, expecting company A to still cooperate because they are under obligation to withdraw the H-1B when the person is not working. And remember, I told you that he'll be Nagarka, Nagatka. We see a lot of consultations coming in October 1st week, though. Why? Because they get kicked out of the civil system. Neither they're in the H-1B, nor they're in the F-1 visa. I hope he's listening. I didn't want to argue with him, but I just want to warn him afterwards.
Makes sense. All right. Rahul Garu, one question before we go to our next caller. This is from Sweet Seller, says, for a GC holder, how is the 180 days stay outside US calculated? Is it 180 days in a calendar year or 180 days continuous?
First of all, to preserve the green card, there are many things needed though, okay? So especially if you are going for 180 days, it's not the calendar year, it's the one-time trip that you make to. So for example, if I make a 4-month trip to India, come back and stay here for 2 months, then I make a 5-month trip to India, it's not considered to be a one straight 180 days. So you will be exempt from that. Okay. But Nitya Garu, for a person to get the citizenship though, there are many slaps that the USCIS is going to hit. You have to escape every one of it though. One of the other thing that people need to aware of that they must be physically present on an aggregate for 2.5 years in the past 5 years.
Okay.
So let's say, for example, 5 months I stay in India, come back, stay here for 2 weeks. 5 months in India, 2 weeks here, 5 months there, 2 weeks here, 5 months there. But at the end of the 5 years, I only stayed 2 weeks every after 5 months though. So that will not be 2.5 years. I will still be get kicked out of the country though. I'm not, sorry, not kicked out of the country, but will not be eligible for citizenship. Sorry, I take back. Citizenship. And people also, the common mistakes that I see for citizenship is that they need to file income tax returns, whether it's a parents, children, everybody has to file income tax returns. Whoever is on the green card. And then you may tell me, Nitya Garu, no, Rahul, I know the IRS rule. Only if you make more than $15,000, you have to make, or something, okay, some amount. You have to file income tax returns. I read the IRS rule. I'm clear on it. That is IRS rule. This is immigration. Every green card holder need to file income tax returns. Then people will say, my mother got 0 income. Fine. Put it 0 everywhere and file income tax.
Got it. Like, so you're basically saying in the returns, even for the period that you lived outside. Is that correct?
Right. Lived outside, lived inside, it doesn't matter. You are a green card holder, you have to pay income tax returns.
You have to pay income taxes.
You have to file income tax returns.
Got it. Thank you, sir. That's actually very useful information. Thank you. All right, let's take our next caller. Caller with number ending in 7291. 7291. We're ready for you now. Hello? Hello?
Hello.
Caller with number ending in 7291. Hello, sir.
Yes, ma'am. Ma'am, I have a question on my H-1B amendment. This is, I have a appointment with on my stamping in June for the H-1B amendment. The question is, recently my office has closed and wherein my client office is near at a distance of 70 meters, and both my closed office and the
we got cut off a little bit.
Hello?
We got cut off, but
Yeah.
let me,
I'm
can you
there
repeat
now.
again, sir? Go ahead. You
Yeah,
said
so,
the closed
my
office and the current office is 70 meters.
No, sir. My closed office is closed. It's not there. No more there at that location. But my client location is 70 meters from the closed office. Okay.
Keep going.
When I checked with my office, they say like since my closed office is within the client's location at 70 meters and falling within the same MSA, they were saying a H-1B amendment is not required.
They're right. They're right.
Yeah. So,
but did the end, but let me ask you this question.
Issue? Yeah.
Did the end client change or the end client is the same?
End client is the same, sir.
End client is the same. Absolutely. I don't see any problem whatsoever at all. So you don't need any amendment. I would not waste any money on immigration lawyer. Next person.
Okay, sir. Thank you so much, sir. Yeah. Thank you so much.
Okay. Thank you, sir. Thank you so much for calling, Andy. All right. Let's take one question before we go to our next caller, Andy. So this is from Naveen Alavilli. Says, can I expect any document or status update after sending my medicals to USCIS during the 485 process? And also, can I apply for an I-131 1 year before existing one's expiring? What if I need to travel to India soon?
Very good questions in both the things. Second question is very interesting question. But first question, let me answer. Once you respond to the RFP, though, the RFP will say that they received the RFP, or it will say that case remains pending. Either of those things are good for you. If you are sending a medical without an RFP, you won't receive anything online.
Okay.
Coming to the advanced parole, and I want everybody who are on advanced parole to listen carefully what this guy is asking the question and my response to it. Typically, the USCIS says that you can only file the extension within 6 months of its expiry. So, but they don't follow the rule. They're taking 17 months to issue the advance parole right now. So is it recommended that you file way before your advance parole expires? Do it. Do it 1 year before. Absolutely do it. Do one other favor to me. Do it within 6 months one more time.
Oh, okay. That's interesting.
Because right now we started testing this thing called apply 1 year before only recently. We don't know when we get these results, when we get the denials, we will find out if we are getting the denial because we filed 1 year before, okay? I would do file it 1 year before, file it within 6 months because anyway, there is no filing fees for you. And the lawyers charge very minimal even if they do. And we offer a thing saying, okay, if you want to file 1 year before, we don't, if it gets denied, we'll refund the money. That's what we do in our office though. And as of now, we did not get any reports though. We tried these things for H4 EAD extensions and H4s. Never had any problem. There were a couple of RFEs. We responded to them. You dumb guys are taking 8 months and you're telling to file within 6 months. Well, we didn't say the word dumb, okay? I'm just telling to our audience. And we got the approval. No problem with it. So file it, guys. And if you get an RFE, please come to us. I'll give a free RFE response to you. If they deny, I can't do anything. But if they give an RFE, please come to us. Okay.
Okay. All right. Thank you, sir. Let's take our next caller, Andy. Okay. Caller with number ending in 4795. 4795. We're ready for you now. Hello.
Hi, Nitya garu. Are you able to hear me?
Hi, ma'am. Yes, I can hear you. Please go ahead.
Okay. Thank you, Nitya garu and Rahul garu, for taking up my call. So our story is the priority date is August 2014, and both I-140s are approved in EB2, EB3, and refiled in EB2, and I-485 is pending in both EB2 and EB3. And on EB3, we got the GC-EAD and AB last year, and EB2 I-485 is pending. It's like we thought it would be done, but at the last moment, the dates retrogress, as you know.
Of course.
So my question is about the GC-EAD. So right now, we've been from the beginning, my husband is on with the services company and with the same company. So now the project is going to end. So we didn't use the GC-EAD yet. I am still on H4 EAD and he is working on H1B. So if he didn't get any assignment or the project within the services company, you know the rule that there is base 2 months. I'm thinking of the worst situation. So what if we couldn't get any project? Like what are the advantage of getting this GC-EAD than H1B? Like,
Right. First of all, I want to save your husband's green card. I'm not interested in H1B. Okay? There is no 60-day rule for the GC-EAD though. So there are many exceptions available for the GC-EAD employment though. Is self-employment allowed in GC-EAD? The answer is yes. Can you, the wife, do you like him that much? I don't know. Just a second. You can even employ.
That's why I'm calling you on behalf of him.
No. Okay. So I know that you employ him to clean the dishes and all those things. You like him to clean the dishes and everything. But can you employ him in his profession? That's another option that's available. Okay. It's a very serious note.
No, sir. My territory is...
Now
my
you can change your territory.
I'm an educator, so...
No, ma'am, you can form a company and employ him, okay? If you think so is worth in that particular profession, you can form a company and employ him. Please note down seriously what I'm telling you. The best option obviously is to find another company and employ. That's for sure. I don't have to tell you, you already know that. The second best option is to have a job offer from a second company and be self-employed, okay? And the third option would be that you form a company and employ. And if you are not willing to do it because, no, this guy is not good in computer science, or I don't like him. Well, he can self-employ himself, okay? These are the four options, but it would be better to have him discuss with a lawyer because you don't have the 60-day rule for the green card. You've been striving for this green card from 2014 to right now. His H1B, we can always get him back to H1B by going outside the country and getting the stamping. And especially in the Trump era, we did all those things. Most of the people went outside the country and stamped and come back though. But I want to keep his 485 alive. I don't want it. So the USCIS can always ask, show me the continuous employment from the past 5 years. Then we can at that point of time argue, I'm self-employed or my wife employed or another company offered me the job. Because when you look into the regulation, he doesn't have to be working in the job. He must have a job offer. Then they may ask question, is it a genuine job offer or not? So keeping his green card alive, find a company that gives him a job offer or form a company and employ him. And if you don't want to help him, I think so he should contact me. I will have him to self-employ and do that work. And is self-employment allowed? Is self-employment allowed on the 485 application? Is it okay to be self-employed? The memo of the USCIS clearly indicates that self-employment is allowed when you are in 485. after you cross 180 days, which I have already taken it from your indication. It's been more than 180 days that you filed the 485.
Yeah. Yes, sir. Okay, yeah, because we don't want to change the company that we've been in because of these laid-offs and all. If you go to any product company, then there are so many other things that we need to take care of. So just to be on the safe side, I'm asking, like, is there any advantage, any positive perks of having the GCEAD? So
absolutely. You don't have to file a H-1B extension. You don't have to provide the end client letter. You don't have to pay the legal fees. You don't have to go for stamping. You don't have to look into the FDNS thing. So many other things. The first thing is getting rid of the immigration lawyer. I like that the most. We'll go to the next person.
Okay. And a follow-up question is that while we are applying, you know, all the chaotic situations back in May and all. So formally we did everything for both EB3 and EB2 separately, but for EB3 we applied EAD and AP, and when we were doing EB2 application in May, the attorney said, anyway, you're going to get green card soon, so we are not applying any EAD AP, because by the time we got EAD AP and the EB3.
You told me that. What's the question?
So if we use that GCEAD, so will we be categorized under EB3 or
No, you're not categorized under EB3 just because you use EAD. We still don't know whether you're EB2 or EB3. Next person, please. Just because you use the EB3,
okay, sir.
EAD doesn't mean that you're EB3.
Okay, sir. And in lighter note, I heard you saying that you are really helpful in getting those H1B and H4 EAD together, approved together, because I also one of the sufferers in last year 21 situation where H4 EAD approved 1 year back.
We're getting paid $20,000 from USCIS for it.
So I'm hoping that will you be able to do something about getting the green cards also so soon, because we've been striving for it for 2020, applying under EB3 and EB2. So
that's on you, man.
So
did you write the letter that we're keeping? No. Did you write the letter? Because I can't do it. Did you write the letter?
Yes.
Okay. So there are certain things that people need to understand. Not everything can go to court, though. Because if a law has to be changed, the judges do not have any right to change the law. They do not have any right to change the law. Absolutely, they don't. Only the Congress, in India we call Parliament, we call Congress. Only Congress has the right to change the law. The courts don't have. When we don't have it, we can't go to the court and say change the law. Okay? Thank you very much, though.
Thank you, ma'am. Thank you so much for calling, Andy. Let's take our next caller. All right. Caller with number ending in 9384. 9384. We're ready for you now. Hello? Caller with number ending in 9384. Please press *6 and need to unmute your line. *6 to unmute your line.
Hear me?
Yeah, we can hear you now, sir. Please
Are you able to hear me?
Yeah, we can hear you.
Hi, Rahul sir, I have one question. So one of my friend, he got laid off from his company and he's in 60-day grace period right now. And, you know, he's still receiving his base salary from his employer. What I wanted to ask you, he has found a new employer who is about to file H-1B transfer petition with USCIS. So in these cases where employee is in 60-day grace period, do you see RFEs coming from USCIS during H-1B transfer, or is it a normal transfer case which gets approved?
Oh, no. We're not seeing any RFEs on it. The only gray area right now is, when does the 60-day grace period start, though? Is it on the day that he got terminated or the day he received the last paycheck? The USCIS says it's been terminated, though. So that's the only thing. But if he got terminated, let's say in January 1st, though, and he is going to file by February 26th, he's going to file the H-1B, do we see any problem? No. It's a grace period, even though it says grace period, though. The USCIS cannot approve for 100 people and not approve for your friend. We can argue that there must be a consistency in the policy of the USCIS. Are there any grounds that they are looking into it? Okay, so it's not like they will approve for 99 people and not approve for your friend. If they do, we can do the motion to review.
Why I am asking this question is because for my friend, the grace period ends on March 12th, and his new firm is about to file the H1B transfer petition on March 1st or March 2nd, which means that by the time approval will come and the person will be able to join on the payroll, it will be over 60 days.
He can start working while H1B is pending. He doesn't have to wait for the approval.
Okay. All right. So it sounds like it should be straight approval then.
Yeah,
okay.
straight.
Thank you very much, sir.
I mean, there might always be other
you.
issues. Like, thank you very much. We'll go to the next person. Nitya Garu, there might be other issues. There might be other issues related to, for example, whether the position requires a degree and all those things. Normal H1B requirement. But if they are filing within 60 days, absolutely, we don't see any denial, none whatsoever at all.
Okay. All right. Thank you, sir. Let's take our next caller, Randy. Okay, caller with number ending in 3082. 3082, we're ready for you now. Hello? Caller with number ending in 3082. Hello? Please press *6 and to unmute your line. *6 to unmute your line. Caller with number ending.
Are you able to hear me?
Yes, sir, we can hear you. Please go ahead.
Hi, Nitya Garu. Hi, Rahul. Thanks for taking my call.
Sure,
this is with respect to CSP age lock. I have an aging out daughter. She's now 20 years and 5 months old. So I was with the employer A in 2012. My priority date is under EB2, February 24, 2012. So I got EB2 I-140 approved through them, and I left employer A by 2019 and joined employer B. And since they started my labor late after a year, and the labor got approved by end of November 22, and I filed my I-140 in premium and 485 together. And so on November 29, 2012, I filed together. So November 2012, by the time my priority date is current in final action date, but my I-140 is approved on December 1st, 2022, during which time my priority date is not current in final action date. It went back, it retrogressed back to October 2011. So I'd like to know, at this, based on the USCIS latest policy, will they honor my, age lock for my daughter?
Because the I-140 must be approved too. And you're telling that your final action dates went, your dates went back though. You're telling your priority date is February 24th, 2012, is that right?
No, 2012. February 2012.
Sorry, 2012. But they are current right now under EB3.
Right. I mean, even under EB2, the filing date is current.
Give me 1 second. Even under EB2, the filing dates. But what does the USCIS give me? USCIS is honoring filing dates for the month of March. I forgot about it. Give me 1 second.
Till this month, they are honoring filing dates from last October.
Okay, so let's speak about March of 2023. Okay, so the four things have to be qualified. Your daughter is under 21. She is that right?
Correct. Right. Yes.
I-140 is approved. Okay.
Yes.
Approved. It's approved. I-485 pending. Yes.
Right.
Filing dates are current. And USCIS has to accept the filing dates. That's another condition. Okay. So in the month of March, I looked into again because I want to double check, make sure that your daughter is safe. In the month of March, the filing dates are acceptable. So you forget about December. In the month of March, she's locked in. I don't know in the month of February, or I don't care. In the month of March, she's locked in.
But I filed my 485 after one year of date being current. Is that okay, sir?
No, that's fine. That's fine. It's not. It was not current. It was not current for this company. The underlying I-140 it was not current.
Company, yeah.
Yeah, the underlying
So
I-140,
under
you told me you
CSPA,
filed in November. Under CSPA, your daughter is locked, sir. She's good.
okay, so CSPA age lock 1 year rule policy, it won't apply for me, right? Okay.
She's locked in. Whether she becomes 30, she's
Okay.
going to get the green card
Sure.
with you. Next person, please.
Okay, thank you very much, sir. Thank you.
Thank you,
Thank you,
sir.
sir.
Thank you so much for calling. All right. Let's take our next caller, Andy. Caller with number ending in. Hold on. 2229. Sorry. 2229. We're ready for you. Hello?
Hello, can you hear me?
Yes, ma'am, we can hear you. Please go ahead.
Hi, thank you for taking the call. So I have a quick question. So I'm on H4 EAD and I'm currently working as a full-time, but I have got another opportunity working as a consultant. So I would like to know, is that okay if I take the two positions?
Absolutely fine. Absolutely fine. No problem with it. Under the immigration law, you can work for 8 different companies. I won't say 9 because I don't know why, but yeah, 9 is perfect too. Somebody asked me, can I work for 9 companies? Yeah, that's fine. You can.
So if the second opportunity becomes as a full-time, I can still take that too, or I shouldn't take that?
You software guys are lazy guys. Working 80 hours is normal for people like for lawyers and doctors, but you IT professionals think that by working 80 hours, you are something like a god or goddesses. No, you damn, sorry, not bad word, but yeah, nothing wrong in it. I don't like people working 40 hours. How do I say that? Man, you can, sorry.
No, that doesn't make sense.
I don't like
But,
people working for 40 hours.
No, my other question was like, I'm
take back, ma'am.
waiting for the
I
green card
apologize,
and my husband. No worries. So I have my husband is in the green card queue and our priority date is EB2 March 2015. So I really want to know, like, does this going to have any impact on the green card queue that we are in?
Zero. You are perfectly doing good. As long as you are not going to do the second job selling marijuana, you're good. Next person, please.
Okay. Okay. Wonderful. Yeah. Thank you so much.
All right.
Appreciate that.
Rahul Garu, you and I are going to have a discussion offline, Andy, about working 40 hours or more.
Yeah.
All right.
That's a fight I have with a lot of other people too. Yeah.
I'm sure. All right. On to our next caller. Okay. Caller with number ending in 3963. 3963. We're ready for you now. Hello?
Yes, I'm here. Yeah.
Yes, sir.
Hello?
We're also here.
Can you hear me?
Yes, sir. We can
Yes,
hear
go
you.
ahead.
Yeah, can you hear me?
Go ahead. Yes, sir. We can hear you.
Yeah.
Please go ahead.
Okay, great. Thank you, Nitya Garu and Rahul Reddy Garu for taking the call,
sir.
and also appreciate your service to this group. My question is, like, I'm currently on H4. I transferred from student visa to H4 here in US, but I don't have any stamping here in US or India. So I'm planning to go to India, but I heard that there is stamping can be done in US. So am I eligible for the stamping?
Right now, we are anticipating the stamping to come up in somewhere at the end of this year, though. And the way initially, they're not going to open up for everybody. We know that back in 2003, when the stamping was open, okay, it was only for the people who are applying the extensions of the H4, extensions of the H1B. It was not applicable for F1 to H4 at that point of time. Now, at this point of time, they have not clearly mentioned to us, whether or not it's going to be applicable for your situation from F1 to H4. They have not clearly mentioned about it. And I don't...
Okay, but I already have the H4 right now.
I know, you said you have only
H4. I even got the H4 EAD also.
That is only H4 797, not the stamping.
Yes, exactly. Correct, yes.
Yeah, so previously when they only did the extensions of the stampings. That means that you have the H4 EAD stamp in the passport, you got the extension of the H4, then we went for the stamping in Washington, D.C. at that point of time, not from F1 to H4. But am I telling you that it's not going to be applicable to you? I don't know. But initially, though, when they start the things, they will start slowly. And the other thing is that typically, though, H4 stamping in India, that is the very most approved visa stamping is H4. I mean, very rarely we get H4 denials. So I'm not telling it's guaranteed, but yeah, okay.
My wife already got H1. She went back in India last year. She got her H1 stamping. So you suggested me to go to India and get it stamped rather than waiting for
that's up to you. That's up to you. That's up to you.
Okay.
We don't know how the new rule is going to be implemented, but typically H4 stampings are more approvable in India.
Easy to go through. Okay,
yeah, easy to go through.
Okay.
Okay, thank you then.
Okay, thank you so much, Andy. Thank you very much. Yeah.
Thank you, sir. Thank you so much for calling, Andy. All right, let's take our next caller. Okay, caller with number ending in 6666. We're ready for you now. 6666. Hello?
Hello?
Hello, ma'am? Hello?
Can you hear me?
Yeah, we can hear you,
can
ma'am.
you hear me?
Yeah, please go ahead. Please go ahead.
Yeah. So I got my green card last year, and when I applied for green card, it was applied for in New Orleans. I was working in New Orleans, and the LCA was applied in New Orleans and then I moved to Houston, and I still work from Houston. Do I need to move back to New Orleans or?
No, ma'am. Welcome to Houston. It's a good city. Why would you go to New Orleans? I'm in Houston too.
Yeah. So
no, you don't have to, ma'am.
So it should
you
be.
don't have to.
Okay.
You're fine.
Okay.
You will have
Thank you
no
very much.
problem with your green card. You will have no problem with the citizenship. And Houston is a good city.
Okay.
People should come in. Low cost of living, unlike Dallas.
Yeah, we love it here. Yes.
Thank you, ma'am.
Thank you very much. Yeah.
All right. Thank you, ma'am. Thank you so much for calling. Let's take our next caller. Okay, caller with number ending in 9411. 9411. We're ready for you now. Hello?
Okay.
Hello.
9411. Hello?
Hello.
Yes, sir. We can hear you. Please go ahead, sir.
Yeah. This is a follow-up question for my wife asked us some time back regarding the H4 F1 to H4. So if suppose my son is working with employer B, while employer A is filed the H1A as a future employer from October 1st. So what would be his status on October 1st if employer B is ready to file? Ready to transfer.
If the H1B is approved on October 1st, though, he will be considered to be on H1B, not F1. But if the H1B is withdrawn, as I said, he will be Nagarka Nagatka.
Yeah, if suppose employer B is filing transfer on October 1st, so can he continue the job with employer B?
Absolutely, because once the file of the transfer has occurred, is right, he doesn't have to get the transfer approved. He can start working on the day transfer application has been filed. So I'm going to look into October 1st, whether it's going to fall into, whether I will look into whether October falls into, October 1st, where it falls into. Yeah, October, I'm going to look into.
Date, if it is Sunday, that's what you mean?
It's on Monday. October 1st is on Sunday. But what they can do is that they can file an application as if that it's going to be delivered on Monday, which is 2nd. So from 2nd onwards, he can start working. So until September 30th, he works for the company. On the 2nd, they file the H1B and can continue working. So he doesn't need to have a break.
Oh, okay. So he don't to, okay. So, and other thing is we cannot apply transfer before October 1st. No. Employer B.
We do not recommend. There are some lawyers who did it that got denied. We don't want to risk it. Thank you.
Okay. Thank you very much.
All right. Thank you, sir. Thank you so much for calling, Andy. Let's take our next caller. Okay, call our number ending in 2188. 2188, we're ready for you now. Hello?
Hello, good evening. Thank you, Nikhila Garu and Rahul, for taking my call. So, my name is Shrikant. Sorry, actually, I have I'm in like a very different situation right now. Maybe I think currently I'm working with a client here full time. Actually, I have H1B like 40 hours. I got like I entered for another job for the client B, but in the last December, so they say actually they got like a final like verbal approval, but because of they have some layoffs in the client B, and maybe they can just came back and actually they only do like a Congress H1B for 20 hours only. But my question is, if I'm working with if I like first H1B like 40 hours, can I do like a Congress H1B with another client 20 hours? Is it allowed, or maybe
Absolutely
I can
allowed.
simply skip the kind of?
Why not?
Okay.
Take it up. You can't work for 60 hours. That's me and Nitya are fighting about it. No, you can take 60 hours.
Oh, it's illegally allowed, right?
Yeah, you can take 80 hours too.
So 80 hours, actually, I think what I understand actually from like some other attorneys, they say you can only allow to work 40 hours in H1B. So maybe that's where actually I have like a lot of confusion with that.
No. Wait. Let me clear this out, okay?
Okay.
First of all, most of the H1Bs come under professional category, professionals. Professionals, there is no limit of 40 hours working. If you have one company, let's say you have ABC Consulting Company, they assigned you for a company, let's say Coca-Cola company, and they are telling you to work for 40 hours. They can even give you another project with AT&T, adding another 40 hours. So they can have you work for 80 hours. And they don't have to pay you extra if they don't want to. That's up to you and up to them, okay? Companies can assign. These are professional jobs. There is no overtime requirement. Now, of course, check with the labor lawyers on this one, though. If you're working for one company, you can have two clients. You don't need any H1B amendment. You don't need anything, first of all. Second, you can have second company also file for a full-time 40 hours, okay? Nothing wrong with it. Doctors working, lawyers do work. Of course, you software guys, sir, I don't want to name it again. Of course, Nitya is going to be angry on me. So, but yeah, so you guys, if you want to, you can choose the same professional, like work like doctors and us. Yes, you can work for 80 hours. Absolutely. Who said that you have to work only for 40 hours? Only, I don't know, Nitya is going to fight against me. So let's,
oh my God,
you can work 80 hours.
You can
thank you,
if you want to.
Thank you, sir.
Yeah.
Okay.
All right, thank you, sir.
Thank you, sir. Thank you, sir.
Thank you so much, sir. Now, folks, I know we have a lot of you all waiting on the calling list as well as the live chat. But unfortunately, as always, we're all out of time today. I do not work 80 hours. I can tell you that much. But 80, it's more like every hour with my children. But other than that, 80 hours, no. But Rahul Garu, thank you so much for being on the show and making sure everybody's working 80 hours a week. My God. That would be so
Nitya, one thing I just want to point out is that nowadays the consultations that I get, though, about 30 to 40% of the consultations that I get are asking only one question: can I work for 80 hours? That's what they pay me $400 just to ask that question.
But on the flip side, I can also see why, like with this recession, the onset of the recession and so many layoffs happening and stuff, I see why people feel the need, to take up the extra work.
More.
So it's not a bad thing to take up this work. I wish nobody had to.
దాని తెలుగులో ఏమంటారంటే దీపం ఉన్నప్పుడే ఇల్లు చక్కబెట్టుకోవాలంటారు.
Yeah, that's it. I wish no one had to, but I can see the need as to why some people have to, take up more than 40 hours of work. But I really hope that, with things proceeding, we see a change in the wave and things get back to normal like how it used to be back in the day. But other than that, we'll be back same place, same time next week to answer all of your questions. and hopefully more ATR weeks. But, until then, you guys have a safe week and we'll see you next week. Thank you so much. Bye.
Thank you, Nitya garu.
Thank you, sir.
మలబార్ గోల్డెన్ డైమండ్స్ ప్రపంచంలో పెద్ద జ్యువెలర్స్ లో ఒకటి ఇప్పుడు డాలస్ కి వచ్చారు. అందమైన తేలికైన జ్యువెలరీ డిజైన్ల నుంచి చేతో తయారు చేసిన అతి క్లిష్టమైన కలెక్షన్ల వరకు 20 దేశాల నుంచి 30,000 విధాల ప్రపంచంలోకెల్లా ఉత్తమమైన జ్యువెలరీ డిజైన్ల అనుభవాన్ని పొందండి. 5,000 చదరపుటడుగల విలాసవంతమైన షాపింగ్ ఏరియా మలబార్ గోల్డెన్ డైమండ్స్ షోరూమ్ ని డాలస్ లో విజిట్ చేయండి. ప్రపంచ స్థాయి జ్యువెలరీని కొనుగోలు చేసే అనుభవాన్ని పొందండి. Malabar Golden Diamonds now open in Dallas.
గెలుపే ఊపిరిగా, పట్టుదలే ప్రాణంగా, ఆశయమే గమ్యంగా పోరాడే యోధుడికి విజయం అన్స్టాపబుల్. ప్రశ్నల్లో మరింత ఫైర్, సర్దాల్లో మరింత సెటైర్, మీకోసం మరింత రంజుగా. దెబ్బకి థింకింగ్ మారిపోవాలా? మీకోసం మరింత రంజుగా.
अब तू देख लेगा बच्चन साहब का खेल.